The Center for Forensic Behavioral Science and Justice Studies, the Center for Research, Evaluation, and Action Towards Equal Justice, known as Create Justice, and the College of Law worked with stakeholders such as the Law Society of Saskatchewan to inform access to justice initiatives in Canada, particularly in Saskatchewan. The purpose of this study was to conduct a scan of justice-related data being collected by legal and non-legal organizations in Saskatchewan, particularly in the domains of civil and family law, to better understand the nature of the data being collected, the accessibility of that data for data sharing purposes, and how amenable agencies in Saskatchewan are to establishing a justice data commons in the province. The three overarching questions examined in this study were: 1, what types of justice-related data regarding civil and family law are being collected by legal and non-legal organizations in Saskatchewan? 2, to what extent are agencies in Saskatchewan practicing within the domains of civil and family law able to share data with external partners? And 3, what are the perceived needs, benefits, and challenges for a justice data commons in Saskatchewan? These questions were answered using two methods: an environmental scan and key informant interviews. The environmental scan was conducted by first reviewing annual reports from the 2020-2021 fiscal year for 24 government, legal, not-for-profit, and other community agencies to determine the type of justice-related data collected by these organizations. Data from the environmental scan was analyzed using two lenses: 1, a content analysis of the type of data contained within the reports, and 2, the application of the Access to Justice, or A2J, measurement framework developed by A2J BC in 2019 to understand the fit of the reported data within this framework. The A2J measurement framework is a justice metrics framework that can be used to monitor and evaluate improvements in access to justice with respect to three domains: improving population access to justice, improving user experience of access to justice, and improving costs. An analysis of 24 annual reports revealed that the data collected from agencies falls within 8 categories: referrals, inquiries, claims, complaints, and appeals received; files opened, services delivered, and file closures; duration of services provided; client demographics; quality of service measures; employee, student, and volunteer data; and financial and population level data. Based on the findings from the data scan, the results recommended prioritizing the most frequently reported data categories for inclusion in the data commons. These categories included data related to the volume and types of initial contacts to an organization, such as requests for services, services delivered, files concluded, the outcomes of the files, and the length of time between commencing and resolving a legal matter. By focusing on these common data elements, agencies will be more likely to perceive themselves as having something to contribute to a data commons initiative, which in turn may increase their likelihood of participation, especially if the data being sought will not require much effort for them to collect beyond their current data collection practices. Further, our study suggested that adopting the A2J measurement framework may create efficiencies in moving forward with the data commons, as it provides a ready-made starting point for identifying common measurement priorities. For instance, the framework could be used to facilitate discussions among justice stakeholders about the types of data that are most important to include in the data commons, including data elements that are most readily available and those for which there are existing gaps. In the second part of this study, key informant interviews were conducted with 14 representatives from 8 agencies, including not-for-profit organizations, organizations that had data commons experience, and provincial government-affiliated organizations. The first subset of interviews focused on agencies with a vested interest in access to justice and explored 3 domains: data collection and usage practices, data sharing practices, and perceptions of establishing a justice data commons in Saskatchewan, including level of readiness for participating in a data commons. The second subset of interviews was completed with an agency involved in a data commons initiative and explored the purpose of the data commons, steps taken to establish the initiative, stakeholders and governance structures involved in the initiative, technical aspects of data sharing, and the strengths and challenges associated with the data commons. Results related to data collection and data sharing practices indicated that the organizations included in the study are actively collecting data and are already engaging in some data sharing practices. Most commonly, the organizations collected data elements that were similar to those identified in the data scan. Most agencies also track data on an ongoing basis and compile data periodically, for example, monthly, quarterly, or annually, depending on the needs of the organization. All agencies, apart from one not-for-profit legal organization, had past experience with sharing data. The agencies most commonly shared data with other government departments, the judiciary, parent agencies such as a national umbrella organization overseeing a provincial chapter, and external partners working on similar initiatives. Two facilitators to data sharing identified in the interviews included having trust in the data recipient and providing the agencies with the monetary resources needed to provide the data requested. Some barriers to data sharing included being hesitant to share data that may be misunderstood or that could jeopardize an organization's funding if it was misinterpreted politically or in the media, having minimal resources to pull, clean, and verify data for sharing purposes, having limited technological experience within their organizations to share data, and having the social license to share data. Specifically, some organizations noted that even if they have the legal right to share data, they will want to ensure that doing so would not affect their clients' trust in their organization. All the interviewees expressed interest in the notion of a provincial justice data commons, with some organizations indicating that they would be willing and ready to participate, and others requiring more information about the intended purpose of the data commons. All provided the caveat that any potential involvement would be influenced by the time and resources required to participate in such an initiative. Based on the results of this study, if action is taken to implement a data commons in Saskatchewan, it is recommended that focus be placed on determining the purpose of the data commons and ensuring it's grounded in a strong framework, determining the primary audience for contributing to and analyzing the data contained within the commons, ensuring that resources are sought to directly support participating agencies, establishing a team for developing the data commons that includes expertise in all necessary areas, and finally, determining the level of data that will be targeted by the data commons.